Welcome back to the Deep Dive. Today, we're getting stuck into a really key piece of legislation, the National Heritage Resources Act 25 of 1999, the NHRA.
That's right.
Whether you're maybe a property owner, a developer, or honestly just interested in how we protect South Africa's past, this should give you a solid understanding.
Mm-hmm. And it's more than just, dry legal text. This act, which actually kicked in on April 1st, 2000, was a major shift.
How so?
Well, it aimed to create a truly integrated and interactive system for managing heritage, moving away from sort of older, more fragmented approaches.
Right.
And a big part of it is about empowering civil society, everyday people to look after their own legacy.
I was really struck by the preamble, actually. It's almost, well, quite moving in parts. It calls our heritage unique and precious.
Exactly, and it stresses that it cannot be renewed.
Cannot be renewed. That's powerful.
It really is. That phrase sets the whole tone. Heritage is treated like a finite, irreplaceable national asset.
So it's not just about old stuff. It's about identity?
Precisely. The act links heritage directly to our spiritual well-being, affirming diverse cultures, helping to redress past inequities, and even fostering empathy. It's positioning conservation as, well, part of reconciliation.
Okay, quite a mission then. So if the act manages the national estate, what does that actually cover? What gets protected?
It's defined incredibly broadly. The national estate basically includes any heritage resource that has cultural significance or other special value for us now and, importantly, for future generations.
And a heritage resource itself is?
Simply any place or object of cultural significance.
That still sounds potentially huge. Are we talking about literally every old potsherd or crumbling wall?
Not quite everything, but the scope is definitely wide. It's not just grand monuments. Think historical settlements, entire townscapes, even landscapes and natural features if they have cultural meaning.
Okay.
Geological sites, too, if they're scientifically or culturally important. And significantly, the Act specifically mentions protecting sites linked to the history of slavery in South Africa.
So making sure those difficult histories aren't ignored.
Exactly. It mandates their inclusion.
Something else that stood out for me was this idea of living heritage. Heritage isn't always something physical you can touch, is it?
No, and that's a key modern aspect of the NHRA. Living heritage covers intangible things, oral history, rituals, indigenous knowledge systems, even, holistic views of nature.
So it protects ongoing cultural practices.
Yes. It moves beyond just digging things up to actively conserving traditions and knowledge that are still alive today.
Okay, let's get into some of the specifics, the legal details maybe. What about archaeological finds? Are there clear rules there, like age limits?
There are. The Act sets specific age thresholds that automatically trigger protection. For most material remains left by people, it's anything older than 100 years.
100 years, okay.
But if it's related to military history, fortifications, battlefields, that kind of thing, the threshold is 75 years.
Yeah.
And for shipwrecks or aircraft wrecks, it's 60 years. Or interestingly, even younger, if SAHRA, the national body, decides it's worthy of conservation.
So age is the first filter.
Mm-hmm.
But how does an authority decide if something, say, a 100-year-old building or a culturally significant landscape is actually important enough to warrant protection? It can't just be age, surely.
No, absolutely not. That's where the criteria for significance come in. Section 3.3 lays this out.
Okay.
They look at various things. Is the place important in the overall pattern of South Africa's history? Is it rare or unusual? Does it have particular aesthetic value?
Aesthetic value. Interesting.
Yeah. Or does it have the potential to yield important information, maybe through archaeological study? And critically, does it have a strong or special connection for a particular community for social, cultural, or spiritual reasons?
So it's about value and meaning, not just how old something is.
Precisely. It's a much more nuanced assessment.
Right. Managing this vast estate from tiny artifacts to living traditions to whole townscapes must require a pretty robust system.
Which brings us to the governance structure, the three-tier system.
Exactly. And underpinning that structure are some core principles. Section 5 is crucial here.
What does it say?
It basically says heritage resources are valuable, finite, non-renewable, and irreplaceable. And it frames each generation as a trustee for the next.
A trustee, I like that.
And it also mandates that heritage management must promote reconciliation and, importantly, guard against heritage being used for sectarian purposes or political gain.
That feels very relevant. Preventing history being sort of
It's a
weaponized.
crucial safeguard, yeah.
So how is the actual management responsibility divided up with these three grades you mentioned?
It's all about significance.
Yeah.
So you have grade 1.
Grade O, the top tier. Yes. These are sites considered to have exceptional national significance. Think, World Heritage sites or places absolutely central to the national story. These are managed directly by the national body, the South African Heritage Resources Agency, SAHRA.
SAHRA. Okay.
Then you have grade 2. These are sites important within a specific province or region. Their management falls to the Provincial Heritage Resources Authority, the PHRA, in each province.
Got it. National, then provincial.
And finally, grade 3. These are resources considered worthy of conservation at the local level. Maybe important buildings in a town or a specific local landmark. These are generally managed by the local authorities, the municipalities.
Okay. Grade 3 sounds like it could be tricky. I mean, are local councils always equipped to handle heritage management alongside everything else they do?
That's a very fair point. Implementation capacity at the local level can definitely be a challenge. But the Act tries to address this through SAHRA's role.
How's
SAHRA's job isn't just managing grade I sites. It's also about setting national principles and standards, maintaining a central database, the National Heritage Resources Library, and coordinating the overall identification and recording of heritage across the country, like the SA Heritage Resources Survey.
So they provide the framework.
Exactly. They set the standards and provide guidance. Even if local resources are sometimes stretched thin, they're the national coordinator and watchdog, essentially.
And SAHRA itself, its structure reflects this national scope.
Yes, it's governed by a council appointed by the minister. And crucially, that council has to have representation from each province. So the aim is to ensure the national strategy considers regional needs and priorities.
Right, that makes sense. Okay, let's shift gears a bit. Let's talk about the practical stuff, the things property owners, developers, maybe even homeowners need to know, the real do's and don'ts. And I guess the big one is the 60-year rule.
Absolutely. Section 34, this is probably the most far-reaching provision for many people.
What does it say?
Basically, it states that no person may alter or demolish any structure or even part of a structure that's older than 60 years without getting a permit from the relevant PHRA, the Provincial Heritage Resources Authority.
60 years?
Yeah.
That's not that old, really. We're talking about buildings from the 1960s, potentially.
Exactly. It catches a huge number of buildings, including much of the mid-20th century architectural stock.
So if I live in a house built in, say, 1960, and I want to renovate my kitchen and knock down an internal wall, legally I need a permit for that, even if the wall isn't structural.
Technically, yes. The term alter is interpreted quite broadly. The idea is to cast a wide net initially to ensure that anything potentially significant gets assessed before changes happen that can't be undone.
Wow. Okay. That forces heritage considerations into everyday planning decisions then.
It does. It has huge implications.
And presumably even bigger implications for large-scale developments, which I guess brings us to heritage impact assessments, or HIAs.
Yes. Section 38 deals with this. Developers have a legal duty to notify the responsible heritage authority right at the start of their planning process if their project hits certain triggers.
Like what kind of trigger?
Well, for example, any linear development, think roads, railways, pipelines, power lines, that's longer than 300 meters.
Okay.
Or any construction or development covering an area larger than 5,000 square meters, or any rezoning or consolidation of urban exceeding 10,000 square meters. These are triggers that suggest a significant potential impact. There are others too, like bulk services or activities in sensitive areas.
And what happens when they notify the authority?
If the authority thinks, based on the notification, that heritage resources might be affected, then it triggers the need for a formal heritage impact assessment report.
And who pays for that?
Crucially, the applicant pays, the developer. The HIA has to identify all heritage resources, assess their significance, evaluate the impact of the proposed development, and recommend mitigation measures. It basically puts heritage on the checklist for major projects.
Okay. Now, what about a really sensitive area, graves and burial grounds?
Section 36. This is handled with extreme care under the Act. There are strict rules about graves older than 60 years, especially those outside formal cemeteries. And there's specific protection mentioned for graves of victims of conflict. That definition includes people involved in the liberation struggles.
Right.
The process for any potential disturbance, like exhumation or relocation, is very rigorous. The applicant must make a concerted effort to consult with and get agreement from communities or individuals who have traditional ties to that gravesite.
So community consultation is paramount.
Absolutely. It takes precedence.
Okay. Shifting from places, to things, movable objects,
Hmm.
art, artifacts, historical documents. How does the Act prevent valuable items from just being sold off overseas?
That's covered mainly under Section 32, dealing with export control. SAHRA is the key authority here.
How does it work?
Essentially, you need a permit from SAHRA to export any object considered a heritage object. This includes things like archaeological finds, objects related to military history, certain types of art, fossils, historical documents, and more.
And what if SAHRA says no? What if they decide an object is too important to leave the country? Can they just block the owner from selling it internationally?
They can refuse the permit if they deem the object is of outstanding significance, and its loss would significantly diminish the national heritage.
Okay. But then what happens to the owner? Are they just stuck with it?
No, and this is a really clever mechanism. If SAHRA refuses a permanent export permit on those grounds, it triggers an option for compulsory purchase,
Meaning?
meaning the state or another public institution approved by the state must offer to buy the object from the owner at a fair market value.
Ah, I see. So the nation gets to keep the object, but the owner is fairly compensated. It balances public interest and private rights.
Exactly. It's a neat solution.
Now, just quickly, is the government itself bound by these rules? Or can state departments do what they like on their own property?
No, absolutely not. Section 9 makes it clear the act binds the state. Government departments have a duty to manage and conserve heritage resources under their control.
Right.
And if they plan any action that could negatively affect a heritage resource they manage, they have to inform SAHRA and give them a reasonable time, usually at least 90 days, to comment before they proceed. Accountability applies across the board.
Good to know. Okay, so we have all these rules, these protections. What happens when someone breaks them? What are the teeth in this act, enforcement?
Right. There are several tools. One powerful one, especially for neglect, is the compulsory repair order under Section 45.
How does that work?
If a heritage authority believes an owner is deliberately letting a protected heritage site fall into disrepair, sometimes called demolition by neglect, perhaps hoping it will collapse so they can redevelop, they can serve an official order on the owner.
Forcing them to fix it up.
Exactly, forcing them to undertake necessary repairs and maintenance.
And if the owner just ignores the order?
Then the authority has the power to step in, do the repairs themselves, and then recover the costs from the owner. It directly tackles that loophole of just letting a building crumble.
Okay, that's quite strong. What about actual penalties for, say, illegally demolishing a protected structure or exporting a heritage object without a permit?
Section 51 and the schedule lay out offenses and penalties, and they can be serious.
Like?
For the most serious offenses like unauthorized destruction, alteration, or excavation of major heritage sites, or illegal export, the maximum penalties can include up to 5 years in prison or a pretty hefty fine, or both.
5 years, okay.
And importantly, the courts can also order the offender to actually put right the damage they caused, or if that's not possible, to pay an amount equivalent to the repair costs to the relevant heritage authority.
Making the polluter pay, essentially.
Kind of, yes. And there's another interesting tool. If an owner is convicted of an offense involving destruction or damage to a heritage resource on their property, the minister or the provincial MEC can impose what's called an order of no development on that property.
Meaning they can't build anything new there?
For a set period, up to 10 years. It effectively freezes development potential on that land, sending a strong message that you can't profit from destroying heritage.
Wow, okay, that really is a significant deterrent.
Mm-hmm.
So this has been a really thorough look at the NHRA. It definitely replaced the old National Monuments Act with something much more comprehensive. If you had to summarize the key takeaways.
I'd say first, the incredibly broad definition of the national estate. It goes way beyond just buildings to include landscapes, underwater heritage, and crucially, living heritage. Second, the clear 3-tier management system. Grade 1st, national SAHRA. Grade 2 SIC, provincial PHRA, and grade 3rd, local.
Right.
And third, the powerful regulatory tools, especially that 60-year rule for structures and the mandatory heritage impact assessments for major developments. It forces heritage into the planning process.
It really embeds conservation into wider development and social goals.
Exactly. Section 5.6 actually talks about integrating heritage conservation into planning processes.
Okay, we've covered a lot about the rules, the regulations, the penalties, kind of the stick approach. But maybe let's end on a slightly different note. Section 42 introduces something called heritage agreements. What are those about?
Ah, yes, that's an interesting one. These are basically voluntary but legally binding contracts. They can be made between a heritage authority and a private owner of a heritage resource, or maybe a local authority or conservation group.
A voluntary contract. To do what?
Well, they can cover various things. Often the owner might agree to certain conservation actions, maybe provide some public access, and in return, the heritage authority might offer incentives like financial help, perhaps technical advice, or even rate rebates.
So it's moving away from just regulation towards partnership.
Precisely. It's a collaborative approach.
So here's something maybe for you, the listener, to think about. If the ultimate goal is effective, long-term conservation, which approach works better in the long run? Is it the threat of fines and prison, the deterrent model? Or is it these voluntary heritage agreements where the state perhaps becomes a partner offering support to a private owner to maintain a shared asset? How might that kind of partnership model really change the whole dynamic between private ownership and the public interest in protecting our national heritage? It's definitely something worth considering.
Yeah, shifting from just enforcing rules to building stewardship together. That's perhaps the future direction the Act hopes for.
Indeed. Join us next time for another deep dive into the documents that shape our world.